You think a cheap suit and a legal pad are going to save you, boy? Officer Bradley Jenkins said it under his breath, just loud enough for David Hutchinson to hear, not loud enough for the court reporter to catch. That was how Jenkins operated. He had been doing it for 9 years. The whisper that couldn't be recorded, the shoulder bump that couldn't be photographed, the smirk that vanished the instant a judge looked up. David didn't respond. He didn't turn around. He set his single yellow legal pad on the defense table, aligned it precisely with the edge of the wood, and sat down. His breathing was 4 counts in, 4 counts out. It was the same breathing pattern he used on the deck of a submarine at 3 in the morning, waiting for an insertion window to open. Courtroom 302 of the Fulton County Courthouse was considerably warmer than the North Arabian Sea, but the discipline was identical. The room smelled of floor wax, old paper, and the particular brand of nervous sweat that accumulates in spaces where people's lives are decided by strangers. The heavy oak benches were 3/4 full for a Monday morning, mostly people waiting on minor infractions, traffic violations. One woman in the back clutching a folder of eviction notices. None of them were paying attention to the man at the defense table, a black man in an off-the-rack navy suit. No attorney, no support team, no one at all in the gallery behind him. Just a man and a legal pad. To everyone in that courtroom, David Hutchinson looked like someone who had already lost and simply hadn't received the paperwork yet. That was exactly the point. David had arrived at the courthouse at 7:45, a full hour and 15 minutes before the docket opened. He had walked the entire building. He had noted the position of every security camera, 14 in total, 3 of which had their lenses angled slightly off-axis, suggesting they hadn't been properly calibrated since installation. He had identified the 2 exits closest to the holding area. He had located the court reporter's station, the position of the witness box relative to the gallery, and the precise angle from which the overhead fluorescent lights would hit the monitor screen when it was deployed from the ceiling mount on the left wall. He had done all of this with the same quiet thoroughness that he had once used to memorize the layout of a hardened compound in Kandahar province before leading a 12-man element through its front door at 0:30. He had also, very deliberately, bought the cheapest suit he could find at a department store in Decatur, off the rack, slightly too tight across the shoulders, the kind of suit that telegraphed to anyone watching, "This man cannot afford better." He had not shaved as closely as he normally would. He had taken public transit to the courthouse rather than the car that was parked. As always, 3 blocks from wherever he actually needed to be. He looked, to all available evidence, like a man who was outmatched and knew it. Jenkins had noticed immediately. David had felt the man's eyes on him from the moment David walked through the swinging gate into the well of the court. He had resisted the reflex to track the movement. Another thing the teams drilled out of you early. Don't signal that you've noticed the threat. Let the threat believe it has the element of surprise. Case number 4-092 was called at 9:03. State versus David Hutchinson, the bailiff announced, his voice carrying the particular exhausted cadence of a man who had read 500 names off 500 dockets and expected to read 500 more. Charges: resisting arrest, failure to comply, and assault on a police officer. David stood, smoothed his jacket, and walked to the defense table. Behind him, at the prosecution's table, Assistant District Attorney Samuel Pearson finally looked up from his file. Pearson was 29 years old, 2 years out of Emory Law, and had already developed the slightly hollowed look of someone processing 4 times the caseload he had been promised during recruitment. He glanced at David, registered the absence of defense counsel, and returned to his file. Open and shut. He had a motion hearing at 11 and a deposition at 2. This would not take long. Jenkins, sitting in the gallery's front row waiting to be called as the state's primary witness, crossed his arms and leaned back with the practiced ease of a man utterly certain of the outcome. He was a heavy-set officer, thick through the neck and chest, with a complexion that flushed easily and eyes that had a particular quality, flat and assessing. The way a certain kind of man looks at the world when he has decided in advance what everything in it is worth. His badge caught the fluorescent light and threw a small, bright point across the ceiling. "There you are," David thought, not looking at him, right on schedule. Judge Margaret Covington emerged from her chambers at 9:07. She was 63 years old, silver-haired, with a reputation among the Fulton County Bar that could be summarized in a single word: exacting. She had been on the bench for 19 years. She had seen every variety of courtroom theater, every flavor of incompetence and manipulation, and she had developed a profound intolerance for both. She took her seat, adjusted her reading glasses, and looked down at David with an expression that managed to be simultaneously professional and deeply skeptical. "Mr. Hutchinson," she began, her voice carrying the dry, slightly raspy quality of someone who had spent 2 decades projecting across rooms without a microphone. "I see you are still unrepresented by counsel. I strongly advised you against proceeding pro se during your arraignment. Are you certain you wish to continue in that manner?" "I am, Your Honor," David replied. His voice was level, not deferential, not aggressive, simply direct. Covington studied him for a moment over the rims of her glasses. In her experience, pro se defendants fell into one of 3 categories: people who couldn't afford representation and were making the best of a bad situation, people who were extraordinarily arrogant and were about to make their situation significantly worse, or, very rarely, people who knew exactly what they were doing and had specific reasons for doing it alone. She filed David in the 3rd category, noted it, and moved on. "Very well. Mr. Pearson, call your first witness." Jenkins took the stand the way a man takes a stage. He swore on the Bible with his chin up. He settled into the leather chair of the witness box as though it were a throne, and surveyed the courtroom with the particular satisfaction of a man who understood that every person in the room was about to hear exactly what he wanted them to hear. Under Pearson's direct examination, a series of gentle, leading questions that Jenkins answered with the smooth fluency of a man who had told this story many times, the events of the night of October 12th were established as follows. Jenkins had been conducting a routine patrol of the Oak Ridge neighborhood, an affluent residential area in the northeastern part of the county, at approximately 11:45 in the evening. He had observed a vehicle, a late-model SUV, dark-colored, operating with what appeared to be a malfunctioning right tail light. He had initiated a traffic stop. The driver, subsequently identified as one David Hutchinson, had immediately displayed what Jenkins described as erratic and agitated behavior. He had refused to provide his license and registration when requested. He had stepped out of the vehicle, without being asked, in what Jenkins characterized as an aggressive manner. When Jenkins had attempted to instruct the driver to return to his vehicle for officer safety, the driver had violently shoved Jenkins backward. Jenkins had deployed his department-issued taser in response. Even then, he testified, the driver had continued to resist, making it necessary for Jenkins to apply physical restraint until a backup unit arrived. He fought like someone who had lost all control of himself, Jenkins told the court, looking directly at Judge Covington with an expression of practiced sincerity. "I've been on the force 9 years. I've had difficult stops before, but this individual he was in a state I can only describe as frenzied. I genuinely feared for my safety." Pearson sat down. "Thank you, officer. No further questions." A brief silence settled over the courtroom. In the gallery, The woman with the eviction folder had stopped shuffling papers. Two men in the third row had turned slightly to watch. "Your witness, Mr. Hutchinson," Judge Covington said. David stood. He did not pick up his legal pad immediately. He stood for exactly 3 seconds. Not dramatically, not for effect, but simply because that was the amount of time it took for him to take one complete breath and confirm that every element of the environment was exactly as he had assessed it. Then he picked up the legal pad and walked to the podium. He did not pace. He did not gesture. He stood at the podium the way a person stands when they have no anxiety to burn off, which is to say, completely still. "Good morning, Officer Jenkins," he said. "Morning," Jenkins said, already leaning back slightly, already performing relaxed confidence for the room. "You testified that you initiated the traffic stop at 11:45 in the evening in the Oak Ridge neighborhood, specifically because you observed a malfunctioning right tail light on my vehicle. Is that correct?" "That's correct." "And your assessment that the tail light was malfunctioning, that was made from behind my vehicle while you were in your cruiser?" "Standard procedure?" "Of course." David looked down at his legal pad. "Officer Jenkins, my vehicle is a 2024 model, leased through a military fleet program operated by the Department of Defense. One of the standard features on that model is an onboard diagnostic system that monitors all electrical and mechanical functions in real time and logs any faults to a secure server. I have here," he walked to the clerk's table and placed a document flat, "a certified diagnostic report generated by the dealership's service department the morning after my vehicle was impounded. The report covers the 48 hours preceding the impound. Defense Exhibit A." "Your Honor." Pearson was on his feet. "Objection, Your Honor. The defense has not provided adequate notice of this exhibit." "Your Honor," David said without turning, "I provided this exhibit to the district attorney's office via certified mail 11 days ago. I have the tracking confirmation and the signed delivery receipt." Judge Covington looked at Pearson over her glasses with an expression that conveyed, without any ambiguity, that she was not pleased. "Mr. Pearson, did your office receive this document?" Pearson's jaw worked briefly. I would need to verify." "The exhibit is admitted," Covington said flatly. "Continue. Mr. Hutchinson," David continued. "The diagnostic report shows 0 electrical faults during that 48-hour window. Officer, no loose connections, no failed bulbs, no intermittent shorts of any kind. Every exterior light on my vehicle was functioning normally on the night of October 12th. He paused. "Does that change your recollection of why you initiated the stop?" Jenkins's jaw tightened. A fine tension moved through the muscles of his neck. A bulb can look fine on a diagnostic and still give off a dim signal at certain angles, he said. "I made a judgment call based on what I saw." "I understand," David said. "Let's move on." He asked about the sequence of events after the stop was initiated. He asked Jenkins to reconfirm, under oath, that David had stepped out of the vehicle aggressively, with his hands clenched into fists. Jenkins confirmed it, with slightly less fluency than before. "I see," David said. "Officer Jenkins, are you familiar with the residential development at 442 Elm Street in the Oak Ridge neighborhood? Specifically, the property at the corner of Elm and Hargrove?" Something shifted behind Jenkins's eyes. Microscopic. If David hadn't been trained to read micro-expressions across cultural boundaries in high-stress environments, he might have missed it. He didn't miss it. "I'm familiar with the street," Jenkins said carefully. "I can't speak to every individual property." "That's reasonable," David said. "The reason I ask is that 442 Elm Street is the address of a private residence that was completed in the spring of last year. As part of the property's security installation, The owners fitted a high-definition infrared camera to the exterior gate, angled to cover the stretch of curb directly in front of the residence. That stretch of curb is the exact location where you initiated the traffic stop on the night of October 12th. Complete stillness from the witness box. Jenkins had stopped leaning back. "I have subpoenaed the footage from that camera," David said. "I provided a copy to the district attorney's office along with Defense Exhibit A. Your Honor, I have a flash drive with the footage and I would request that the court monitor be deployed." "Bailiff," Judge Covington said, and her voice had taken on a quality that was not quite anticipation but was in the same neighborhood. "Set up the monitor." The monitor descended from the ceiling mount with a mechanical hum that seemed very loud in a room that had gone very quiet. Pearson was standing at his table, staring at his file folder with the expression of a man trying to remember whether he had reviewed a piece of evidence that he was now quite certain would have changed his entire morning if he had. He had not reviewed it. He had received 2 certified mail deliveries in the past 2 weeks from a pro se defendant, and his paralegal had logged them in the system, and Pearson had made a mental note to review them when he had time. And he had not had time. And here they were. "You've had this for 11 days. Mr. Pearson." The words were going to be living in his head for a considerable while. The flash drive was inserted. The court reporter adjusted her position slightly to see the screen. The woman with the eviction folder had put the folder entirely away and was sitting forward with her elbows on the bench in front of her. Jenkins gripped the wooden ledge of the witness box. His knuckles had gone pale. The footage was black and white, infrared, high resolution, time-stamped in the upper right corner. The timestamp read 23:47:12 when the recording began. 2 minutes and 12 seconds after Jenkins had testified the stop was initiated. The camera angle covered the full width of the street in front of 442 Elm. It was a wide shot, the kind that sacrifices close detail for comprehensive coverage. But the detail it did capture was, in the particular circumstances, more than sufficient. The recording showed David's vehicle, the SUV, clearly identifiable by its distinctive roofline and wheel profile, pulling to the curb smoothly and coming to a complete stop. No erratic movement, no sudden braking, a clean, deliberate pullover, the kind you perform when you have nothing to hide and have been pulling over cleanly for 11 years of driving. 6 seconds later, Jenkins's cruiser appeared from the right edge of the frame. It came in fast, aggressively fast, the kind of approach angle that in a tactical context would be characterized as threat-dominant rather than auto-safety-oriented. The cruiser angled in hard, coming to a stop at an acute angle behind David's vehicle rather than the standard parallel offset that procedure recommended. Jenkins got out of his cruiser. He walked to the driver's side of David's vehicle. David did not get out of his vehicle. The footage showed the driver's door remaining closed, the window rolling down, and a brief exchange through the open window. 11 seconds. Then Jenkins's right arm extended, grabbed the door handle, and wrenched the driver's door open with the kind of force that was not consistent with a standard traffic stop interaction and was not consistent with an officer responding to an aggressive subject. It was consistent with an officer who had already decided what was going to happen and was making it happen. David's hands were visible the instant the door opened. They were raised, palms outward, in the universal posture of compliance. They were not clenched. They had never been clenched. Jenkins grabbed him by the collar. The next 8 seconds were difficult to watch. Jenkins pulled David out of the vehicle with one hand and used his body weight to drive David down and forward, sending him onto the wet asphalt. David's palms hit the pavement. Before he had fully registered the ground, Jenkins's knee drove into the center of his back. Full body weight, deployed with the kind of force that in a training context would have been immediately flagged as excessive, and the taser was deployed into David's shoulder at point-blank range. David did not fight back. The footage was clear on this point beyond any reasonable interpretation. He went limp the instant the taser discharged, and even before that, his arms had remained in a compliance position throughout. The courtroom was not quiet. It had moved past quiet into the kind of collective held breath that precedes a sound too large for the space. Judge Covington's gavel came down, once hard. Order. David turned off the footage. He did not look at the screen. He had seen it before. He had reviewed it 14 times in the weeks preceding the trial, at different speeds, from different distances, noting every frame. He kept his eyes on Jenkins. The man in the witness box had undergone a visible transformation. The practiced ease was gone. He was gripping the ledge with both hands, his jaw set. The flushed complexion of his face deepened to something mottled and uneven. A vein pulsed at his temple with the kind of visible urgency that belonged in a medical observation, not a courtroom. "Officer Jenkins," David said, and his voice dropped perhaps half an octave. Not a performance, a command register, the voice he used when he needed something to penetrate noise and adrenaline and reach the part of a person's brain that still processed information when everything else had stopped working. "Would you like to revise your sworn testimony?" The silence that followed was the heaviest thing in the room. The angle of the footage," Jenkins began. His voice had lost its certainty. It was searching. "It doesn't show the context. Before the door opened, you were reaching under the seat. I could see movement through the window. I couldn't tell what—" "Reaching under the seat?" David repeated. He returned to his table and lifted another document. "That's interesting. Because I have here the official inventory report of my vehicle, completed by your partner, Officer Raymond Miller. At the time of impound, the vehicle was found to contain 1 gym bag in the rear cargo area, 1 emergency kit in the center console, and the vehicle's standard documentation in the glove compartment. No weapons, no contraband, nothing under any seat." He submitted the document. "Defense, Exhibit B." Jenkins said nothing. His mouth was open slightly, but nothing was coming out. "Furthermore," David said, returning to the podium, "I'd like to address the question of protocol. You testified that you feared I was reaching for a weapon. Officer Jenkins, you've been on the force for 9 years. You know the response protocol for a situation where you observe a subject potentially accessing a weapon through a vehicle window. You draw your service weapon. You move to a position of cover, typically behind your engine block. You issue verbal commands. You do not holster your weapon, walk to the driver's door, and manually pull the door open. That sequence of actions is not consistent with an officer acting out of fear for his safety. It is consistent with an officer who has already decided to use force and is creating the conditions to do so." "Objection." Pearson stood, and his voice had the quality of a man performing a reflex rather than making a legal argument. "Counsel is testifying and badgering. Mr. Hutchinson," Judge Covington said, "keep to questions. But Officer Jenkins—" And here her voice did something David had not heard it do before, which was carry a distinct undercurrent of barely restrained fury. "You remain under oath. I suggest you choose your next words with that in mind." David looked down at his legal pad. The next question was the one he had been building toward. Not the question itself. The question was straightforward enough, but the placement of it, the angle, the way it would land after everything that had preceded it. Timing in an interrogation. He had learned from instructors who had spent careers in rooms with people who were trained not to break. Was not merely about when you asked. It was about what the person was carrying when you asked. You let the weight accumulate. Then you added the last pound. "Officer Jenkins," he said, "my blood toxicology report, taken at intake, approximately 90 minutes after the traffic stop, shows 0 detectable substances, no alcohol, no narcotics, no prescription medications above therapeutic levels. I've submitted it as Defense Exhibit C." He paused. "Let one breath pass. You've testified that I was behaving in what you called a frenzied manner, that I fought like someone who had lost all control of himself. The toxicology is clean. The video shows compliance. There are no injuries to your person documented in any medical record submitted by the state. There are, however, medical records for me, a dislocated left shoulder, a grade 2 concussion, and contact burns consistent with a taser discharged at extremely close range to bare skin." He let that sit for exactly 4 seconds. "Let me ask you this, officer. In your 9 years on this force, in all of the traffic stops you've conducted, and in all of the use of force incidents in which you've been involved, have you ever once, in any single incident, been the one who required medical attention afterward?" Jenkins stared at him. "Because I've reviewed your incident reports," David continued, his voice measured and unhurried. 14 use of force incidents in 9 years. 14, and in every single one, the individual on the receiving end of the force required medical evaluation. You never did. Not once." He tilted his head slightly. "Does that pattern reflect good officer safety training, in your view? Or does it reflect something else?" "Objection." Pearson was standing again, and this time there was genuine alarm in his voice, not just reflex. "Your Honor, the defense is introducing pattern evidence that was not disclosed. I disclosed it in Defense Exhibit D, delivered with the other materials," David said without turning. "The FOIA request that produced those incident reports was filed 6 weeks ago. It's all documented." Covington looked at Pearson with an expression that had passed through impatience and arrived somewhere in the vicinity of genuine displeasure. "The objection is sustained as to the characterization," she said. "The jury will disregard the final question. Mr. Hutchinson, you will ask questions, not editorialize." She paused. "But I want to be absolutely clear. Officer Jenkins, you are under oath. If you are sitting in that witness box and fabricating, this court will not forget it." Jenkins had stopped performing. The man who had swagger-walked past David's table and bumped the corner with his hip had been replaced by someone who was sitting very still and staring at a spot on the floor just beyond the witness box ledge, with the expression of a person doing internal calculations that were not coming out in his favor. David turned his back. It was a deliberate choice. Not disrespect for the court. He was moving toward his table, which was a reasonable and natural action. But for a man like Jenkins, a man whose entire operating framework depended on being the most dangerous presence in any room, being turned away from was processed as something more fundamental than insult. It was dismissal. It was the signal that you were no longer a threat worth tracking. Something in Ibokan's internal architecture, the part that had been running on 9 years of unchecked authority and the certain knowledge that consequences applied to other people, overloaded. Later, reviewing the court's own recording of what happened next, David would note that Jenkins's face showed 3 distinct stages in a span of approximately 1.5 seconds. First, the flush of rage, rapid and total. Then a microsecond of something that might have been a final warning from whatever remained of his rational mind, and then the absence of anything but forward momentum. "I'm not done with you," Jenkins said. His voice had no courtroom texture left in it at all. It was something raw. "You arrogant son of a—" He was out of the witness box before the bailiff registered the movement. The courtroom understood what was happening before it consciously processed it. The woman with the eviction folder made a sound. The two men in the third row both leaned backward simultaneously. Pearson, in the act of reaching for his coffee cup, went completely still. Jenkins crossed the open floor of the court in 3 heavy strides. He bypassed the swinging gate, bypassed the positions of every person in the room, bypassed every last mechanism of protocol and restraint, driven by 9 years of accumulated certainty that his size and his badge and his particular brand of anger could solve any problem he chose to apply them to. He reached for David's neck with both hands. He never made contact. David Hutchinson was a chief petty officer in the United States Navy Special Warfare Community. He had completed 4 combat deployments across 3 theaters. He held an instructor certification in close quarters defense that required annual requalification. His situational awareness was not a skill he could turn off. It functioned the way breathing functioned, not because he chose to engage it, but because it had been trained into him at a cellular level over the better part of a decade. He had heard the squeak of Jenkins's boots on the floor the moment the man started moving. He had felt the shift in air pressure, the displacement of a 240-pound body moving at speed through a confined space, before the gallery had registered that Jenkins was standing. He had a full second and a half to make his assessment and select his response. He did not panic. He did not swing. He dropped his center of gravity 2 inches, pivoted on his left heel, and redirected. His left hand came up and caught Jenkins's right wrist. Not blocked, redirected, using the man's own momentum as a lever. He stepped to the outside of Jenkins's charge, twisted the captured wrist upward and back, applied immediate and precise pressure to the elbow joint, the minimum force required to produce compliance and immobility, and swept Jenkins's right leg with a controlled movement that removed his base of support without endangering his spine. Jenkins went down face first. The impact shook the floorboards. David's knee pressed into the back of Jenkins's neck. Not the windpipe, not the cervical spine, but the trapezius, applying the specific amount of weight required to eliminate the ability to rise without causing structural damage. "Freeze! Get off him! Get back!" The bailiff, a man named Henry, who had worked courtroom 302 for 11 years and whose primary professional challenge on most mornings was keeping people from using their phones, had his weapon drawn, his hands shaking, the muzzle pointed at the general vicinity of the 2 bodies on the floor with the specific targeting precision of a person who was experiencing a significant departure from the parameters of his job description. Judge Covington's gavel came down 3 times in rapid succession. "Henry, lower your weapon." The bailiff's eyes went to the judge. His weapon arm dropped by approximately 15 degrees, not holstered, but no longer pointed directly at a sitting defendant. "Mr. Hutchinson," Covington said, and her voice had changed. The dry professionalism was still there, but underneath it was something that sounded, if David was reading it correctly, like a woman who was operating at the outer edge of her experience and choosing not to show it. "Release him. Now." David looked up at her. His breathing was still 4 counts in, 4 counts out. Jenkins was making small, furious sounds against the floor. "With respect, Your Honor," David said, "I'm going to decline." The silence that followed this sentence was of a quality that David thought could probably be measured with instruments. "I beg your pardon," Covington said. "This officer is still armed." David said. He spoke with the measured pace of someone explaining a procedure that should be obvious, but was apparently not. "He has a Glock 19 in his duty holster, a taser on his left side, an OC spray on his belt. He has just demonstrated, in this courtroom, that he is capable of making a violent physical assault with no warning and no provocation. If I release him before he is disarmed by another sworn officer, the probability of further violence is not theoretical." He kept his eyes on the judge. "I am performing a citizen's arrest for aggravated assault. I will maintain the hold until someone with a badge and lawful authority to do so removes his weapons. That is not insubordination, Your Honor. That is risk management." Jenkins tried to raise his head. David applied slightly more pressure to the trapezius. "Don't," David said quietly, and the single word landed with the particular weight of a man who was not making a request. Covington looked at Henry. Henry looked at Covington. "Henry," the judge said, "take his weapons. Now." The bailiff holstered his own weapon, approached the two figures on the floor with the cautious movements of a man navigating an environment he had not been trained for, and knelt beside Jenkins. He unclipped the duty belt, pulled the Glock from its holster, removed the taser from its clip, and slid the OC spray free. He dragged the entire belt assembly across the floor, away from Jenkins's reach. David stood up. He released the joint lock in a single clean motion and stepped back. He brushed a small amount of floor grit from the knee of his cheap suit and straightened his tie. Jenkins scrambled to his feet. His face was the color of a brick. His right elbow was bent at an angle that suggested it was not happy about recent events, and the last remaining shred of his public composure was gone completely. He looked at David with an expression that had moved past anger into something more primitive and considerably more specific. "You're dead," he said. His voice was barely above a whisper. "You hear me? You're going to prison for the rest of your... Mr. Jenkins," Judge Covington said, and the temperature in her voice was something you could have measured with a thermometer and gotten a number below freezing. "You will be silent." Jenkins's mouth closed. David looked at the judge. "Your Honor," he said, "as the victim of an unprovoked physical assault that occurred in open court and is captured on the court's own recording equipment, I have a request." "Speak," Covington said. "I'd like to make a phone call." Covington blinked. It was a very small blink, but it was there. "Mr. Hutchinson, you are not the individual under arrest here. Officer Jenkins is in contempt of this court, and I assure you this matter is being referred to. Internal affairs won't be necessary for this particular matter, Your Honor." David said. He reached into the inner breast pocket of his jacket, the one tailored, in defiance of the rest of the suit's deliberate cheapness, to accommodate exactly the device he now withdrew, and held up a phone. It was not an iPhone. It was not a Samsung or any other consumer device. It was matte black, thicker than a standard smartphone, with a rubberized casing and no manufacturer logo visible. The kind of device that the people who use it do not discuss with people who don't need to know about it. "This is a federally encrypted satellite communication device," David said, for the benefit of the court reporter. "I am making one call. I would ask that the court allow it." Covington looked at him for a long moment. "Make your call, Mr. Hutchinson," she said finally. "And then you are going to tell me exactly what is happening in my courtroom." David pressed a single key. The call connected in less than 2 seconds. No dial tone, no rings, just the particular quality of silence that meant an open, secure line. "Control, this is Chief Hutchinson," he said. "Authentication, Alpha Romeo 9er. The target has engaged. Escalation confirmed. Physical assault on my person. Open court. Fully recorded on county systems. Phase 3 is authorized. Execute." He listened for 4 seconds, nodded once, ended the call, slid the phone back into his pocket. He turned to face the courtroom. Jenkins was staring at him. Pearson was staring at him. The bailiff, Henry, was staring at him. The gallery, which had gone from mildly interested Monday morning foot traffic to witnesses of something that none of them would have adequate language for at dinner that evening, was staring at him. Judge Covington removed her glasses, cleaned them on her robe, replaced them, and said, in a voice that was doing considerable work to remain professional, "Mr. Hutchinson, who did you just call? And what, in the name of this court, is Phase 3? David walked to the bench. Not the podium, the bench itself, the raised platform of the judge's station, stopping at the appropriate distance but close enough that what he said next did not need to be loud. "Your Honor," he said, "I'm going to ask you to hear what I'm about to say before you rule on whether I should have said it. I understand that's unusual. I'm asking it anyway, because the next several minutes are going to be unusual regardless, and it will be cleaner if you have context." Covington held his gaze. She had the eyes of someone who had spent 2 decades reading people in high-stakes situations and did not easily miss things. What she saw in David's face, the absence of anxiety, the complete, absolute stillness of a person who is not uncertain about a single element of what they are about to say, did not lead her to the conclusion that this was a man having a breakdown. She nodded, almost imperceptibly. "Speak." "I am not a civilian defendant," David said. "I am Chief Petty Officer David Hutchinson, United States Navy Special Warfare Command, currently operating on detached assignment with a joint federal task force consisting of the Naval Criminal Investigative Service and the Department of Justice Civil Rights Division." He spoke quietly, cleanly, with no inflection of drama. This was a briefing. "The vehicle I was driving on the night of October 12th was a federally supplied surveillance vehicle, a bait car, equipped with 4 concealed 4K audio-visual recording devices, biometric sensors, and a direct uplink to an FBI surveillance van operating 3 blocks from the traffic stop. Every second of what happened that night, from the moment Officer Jenkins's cruiser activated its lights to the moment the backup unit arrived, is in federal custody." From behind him, Pearson made a sound that might have been a word. "The traffic stop was not incidental," David continued. "Officer Jenkins and his partner, Officer Raymond Miller, were identified 8 months ago as the primary figures in a predatory enforcement pattern targeting black men in affluent Fulton County neighborhoods. The pattern involved pretextual stops, unlawful searches, seizure of cash from vehicles under civil asset forfeiture, evidence planting, and in at least 2 documented cases, physical assault of individuals who posed no threat. We needed an individual who could undergo the stop, absorb whatever happened, maintain absolute physical and emotional discipline throughout, and preserve the integrity of the evidence chain. That individual needed to be someone Jenkins would immediately assess as a safe target, someone who looked, on the surface, like he had no resources and no recourse." He paused, just briefly, the pause of a man who has rehearsed this speech many times and knows exactly where the weight belongs. "I volunteered," he said. The heavy double doors at the rear of courtroom 302 opened. The sound they made was not loud, but it was definitive, the sound of large, well-maintained hinges moving under controlled force, the sound of people who are not in a hurry because they have already won, entering a room to complete the process of winning it. 5 individuals walked down the center aisle. 4 wore dark suits with FBI credentials clipped at the breast pocket. The 5th was a tall man, late 40s, silver at his temples, who moved with the economic precision of someone who has learned over a long career that deliberate stillness communicates authority more effectively than any amount of speed or volume. Special Agent Richard Kinsley, Federal Bureau of Investigation, Public Corruption Unit. He bypassed the swinging gate without breaking stride, approached the bench, and presented his credentials to Judge Covington with the ease of a man who has done this in better courtrooms than this one and worse ones. "Your Honor," he said, "I apologize for the interruption. We were monitoring the live feed from Mr. Hutchinson's covert wire. When the subject initiated physical contact, we moved. Covington looked from Kinsley to David to Jenkins. She looked at the court reporter, who was typing with the focused energy of someone aware that they were creating an official record of something that would be cited in many documents over many years. "Agent Kinsley," she said slowly, "are you telling me that this entire proceeding—" "Not the proceeding, Your Honor," Kinsley said. "The proceeding was organic. The trial was simply the environment we provided to Officer Jenkins. We gave him a room, a witness box, and a man he thought he had already beaten. What he chose to do in that room, a brief pause, was his own work. Jenkins had not moved from the spot where he had risen from the floor. He was standing between the witness box and the gallery rail, his duty belt gone, his elbow wrong, his face the color of something left in the sun too long. The FBI agents who had entered with Kinsley had positioned themselves with the casual competence of people who do this regularly, two flanking the room's exits, two closer to the center of the space, everyone within response distance of everyone else without making the arrangement obvious. Jenkins was looking at David Hutchinson in the way a person looks at something when they are trying to reconcile what they are seeing with every assumption they have built their life upon. "This is," he started, "this is a setup. Judge, this man lied to this court. He was never— He's not any." "Officer Jenkins." Kinsley's voice was not loud. It didn't need to be. It had the particular quality of a voice that has spent years cutting through rooms full of people saying things that weren't true, and had developed a natural frequency for ending that kind of noise. "I'm going to need you to stop talking." Jenkins stopped. Kinsley opened a slim leather folder and produced 3 documents, which he laid on the clerk's table. "Your Honor, the first document is a sworn affidavit from the Director of the Naval Criminal Investigative Service, confirming Chief Petty Officer Hutchinson's assignment to the Joint Task Force and the legal authority under which his cover identity was established. The second is a mandate from the Attorney General's office, authorizing the deployment of the bait vehicle and the covert recording operation. The third," he slid the third document slightly to the left, "is a federal arrest warrant for Bradley Jenkins, issued this morning by the Honorable Patricia Stearns of the Northern District of Georgia." Pearson sat down, not deliberately. His legs simply resolved the situation on his behalf. "The charges," Kinsley continued, "are as follows: deprivation of rights under color of law, in violation of Title 18, United States Code, Section 242, aggravated assault on a federal officer, perjury, obstruction of justice, and," he returned to the folder, "civil asset forfeiture fraud, specifically the conversion of seized funds for personal use." Jenkins's mouth worked. "You can't. I have union representation. I have a right to—" "Your union representation," Kinsley said, with the precise, measured cadence of someone reading from a memorized list of items that are all individually bad news, "is Thomas Gable, who, at approximately 8:15 this morning, was taken into federal custody at his home in Marietta on a separate set of charges arising from the same investigation. His attorney has advised him not to make statements. I would extend the same advice to you." The room's silence had texture now. It was not the silence of shock that had passed, but the silence of a large space in which the air has been entirely replaced by the weight of what is happening. Pearson was on his feet again. Whatever had briefly paralyzed him had resolved into a kind of frantic professional energy, the energy of a man running the calculations on how far from this situation he could realistically get, and how fast. "Agent Kinsley," he said, and his voice had the slightly high quality of a man working very hard to sound composed. "My office has jurisdiction over state charges. If there is a concurrent federal investigation, standard interagency protocol requires that the district attorney be briefed." "Mr. Pearson?" Kinsley turned to look at him slowly, the way a person turns when they have been waiting for a specific thing to be said. In the past 3 years, your office has received 22 separate excessive force complaints involving Officer Jenkins. They were reviewed by the DA's Office Complaint Division. 18 were dismissed without investigation. 3 were referred to Internal Affairs, a process that, in the case of this particular precinct, has historically produced outcomes indistinguishable from dismissal. 1 is currently pending. He paused. We have your office's internal communications regarding several of these complaints. We have the emails. Mr. Pearson. We have the memos. We have the routing decisions. And we have the fact that the district attorney's recent re-election campaign received a significant fundraising contribution from the Metropolitan Police Officers Benevolent Association, which is an association whose leadership has overlapped substantially with Officer Jenkins's unit for the past 6 years. Pearson sat back down. His face had resolved into a single expression that contained no performance at all, just the pure, unmediated affect of a man understanding, in real time, that his professional morning had become something significantly more complicated than a motion hearing and a 2 o'clock deposition. We are not here for you today, Mr. Pearson, Kinsley said, with something that was almost, but not quite, charitable. What you choose to do in the coming weeks will determine whether that changes. I would suggest you consult personal counsel before it does. Kinsley turned back to the bench. Your Honor, I want to address one additional element of the investigation, because it is directly relevant to cases that have passed through this court. He paused. Officer Jenkins's partner, Raymond Miller, was taken into federal custody at 6 this morning. He has provided a full statement. Among the items he confirmed, the planting of controlled substances in the vehicle of Marcus Weaver, a 22-year-old engineering student, on September 3rd of last year. Mr. Weaver is currently serving a 5-year sentence in a state facility. He has been there for 7 months. Miller confirmed that there was no marijuana in Mr. Weaver's vehicle. The bag was Jenkins's. Miller put it in the trunk himself while Jenkins kept Weaver occupied at the front of the car. The sound that moved through the courtroom was not a gasp. It was something that started lower than that. A release. An exhalation. The collective breath of people who have been told something that makes the world slightly worse and slightly more comprehensible at the same time. Judge Covington had been very still during Kinsley's presentation. She was still now. But something in her face had changed, or rather, something had left it. The professional composure was still intact, but the thing that had been underneath it, the careful suspension of full judgment that good judges maintain through proceedings so that they can rule on the facts, had been replaced by something more direct. She looked at Jenkins the way a person looks at a thing that has violated something fundamental. "Is this true?" she said. Her voice was quiet, which made it considerably more frightening than if it had been loud. "Is what this agent has described true, Officer Jenkins? Have you been using this court, my court, to put innocent people in prison? To cover what you were taking from them?" Jenkins said nothing. His knees had developed the micro-tremor of a person whose body is processing a very large amount of cortisol with nowhere to put it. His left hand, hanging at his side, was opening and closing slightly. The motion of a man reaching for something that is no longer there. 2 of the FBI agents moved toward him. One touched his shoulder. Gently, in the way that professionals in their specific line of work have learned to make an inevitable thing feel slightly less abrupt. "Bradley Jenkins," Kinsley said, "you are under arrest. Please place your hands behind your back." There was a moment, then, that David had not planned for, which was the only indication that the preceding weeks of meticulous preparation had been, at their foundation, a very human thing. He had thought about this moment. He had thought about it on late nights in the safe house apartment 3 miles from the courthouse, reviewing footage and legal documents until his eyes ached. He had thought about whether he would feel satisfaction, or relief, or the particular catharsis of watching something broken being repaired. He had imagined himself experiencing something clean and decisive at the end of this. What he actually felt. Watching Jenkins's shoulders finally drop, watching the manufactured authority drain out of the man's body like water out of a broken vessel, was something quieter and more complicated. It was not satisfaction. It was the feeling you get when a mission ends, the profound, exhausted, slightly hollow awareness that the operational phase is over and what remains is the long work of whatever comes next. He thought of Marcus Weaver, 22 years old, engineering student, sitting in a state facility right now, having been there for 7 months, for a crime that never happened. David had read Weaver's file twice. He had read the original stop report, written in Jenkins's particular style, authoritative, confident, riddled with the linguistic tics of a man who has learned that certain phrases produce certain official outcomes. He had read Weaver's sentencing transcript. He had read the appeal that had been denied 6 weeks before David made contact with Kinsley's unit. He had also read a photograph. If reading was the right word for the thing you did when you looked at a 22-year-old's face in a case file and understood. With a kind of cold precision. What a year of that person's life was worth. He had agreed to do this job in a legal office with fluorescent lighting and a very good cup of coffee and 2 federal agents explaining the parameters of the operation. He had signed the paperwork and shaken the hands and walked out of the building and driven to the department store in Decatur to buy a cheap suit. He had done all of this, he told himself, because it was a mission, and he had been given missions harder than this one. And the discipline required was well within his operational range. Oh, that was true. It was also not the whole truth. The whole truth included his cousin. James, who was 24 years old and studying pre-medicine at Georgia State when Jenkins had stopped him 2 years ago on a Tuesday evening on Peachtree Street and put him in the hospital with a traumatic brain injury severe enough to permanently reduce vision in his left eye. And the Internal Affairs Division had reviewed the incident and produced a finding of justified use of force. And the union had backed that finding. And the district attorney's office had declined to open a criminal investigation. And James had withdrawn from his program and gone home to his mother's house in Macon and was still there, working in a hardware store, the left side of his vision a permanent shadow. David had not told Kinsley about James during the initial recruitment. He had told him afterward, when the paperwork was already signed. "Does that change your assessment of my objectivity?" David had asked. Kinsley had looked at him for a moment. "Does it change yours?" He'd replied. "No." David had said, "Then we're fine." Kinsley had said, Jenkins was being handcuffed. The agents were professional about it. No theater. No excess force, the quiet, efficient movements of people performing a function rather than making a statement. Jenkins's face was turned slightly to the side, away from the room, in the automatic reflex of a person who is not ready to be seen in this condition. David walked to the bailiff's desk. Henry watched him approach with the expression of a man who had decided the best professional strategy at this juncture was to not be surprised by anything. David picked up Jenkins's duty belt from where it had been slid across the floor. He unclipped the handcuffs from the belt, standard department issue, matte steel, the kind that had been placed on the wrists of people who had never done anything to deserve it, and held them out to the nearest FBI agent. "Use these," he said. The agent looked at the cuffs, looked at David, and took them without comment. He clicked them around Jenkins's wrists with the particular sound that those devices make, a mechanical ratcheting that is functional and small and, in the right context, contains multitudes. Jenkins made a sound when the cuffs tightened over his injured elbow. It was not a dignified sound. Judge Covington struck her gavel one final time. The sound didn't have the urgency of her earlier strikes. It had a different quality, the sound of something being formally and permanently closed. "Mr. Pearson," she said, her voice carrying the flat authority of a ruling that was not open to discussion. "You will file a motion to dismiss all charges against Mr. Hutchinson with extreme prejudice before close of business today, not tomorrow. Today." "Yes, Your Honor," Pearson said. He said it with the velocity of a man who wants to be agreeable about everything in the room right now and for the foreseeable future. "Furthermore," Covington continued, and her voice did not change tempo or pitch, which made what she said next land with the weight of something that had been considered carefully rather than spoken in heat. "I am ordering a comprehensive judicial review of every conviction secured in this courthouse, where Officer Bradley Jenkins was the primary arresting officer. Every case, every year of his service. My office will coordinate with the federal authorities, and I expect full cooperation from the district attorney's office with that process." She looked at Pearson with an expression that clarified, beyond any ambiguity, that she was not making a request. "If I encounter obstruction from anyone in that office, at any level, I will hold the district attorney personally in contempt. Are we clear?" "Perfectly clear, Your Honor," Pearson said. Covington turned to Jenkins, who was being held upright between two agents near the gallery rail. She looked at him for a long moment before she spoke. When she did, her voice had the specific quality of a person who has spent a very long time believing in a system and is now required to confront, in very personal terms, what happens when that system is weaponized by people entrusted to operate it. "You wore that uniform," she said. "In this courtroom, on this bench, in front of me. You put your hand on a Bible and you lied. You used the authority that this court extended to you, that this court vouched for, to imprison people who committed no crime against anyone. You took from them. You hurt them. And you stood here, today. And you were going to do it again." A pause. "I cannot sentence you today. That will come in its proper time. But I am going to write to the sentencing judge when that time arrives. I am going to write a personal letter, and I am going to recommend that you serve every day of whatever sentence is handed down without any of the considerations that are sometimes extended to former law enforcement officers." She looked at the agents holding him. "Get him out of my courtroom." Jenkins said nothing. Whatever had been running on the power of his certainty and his badge and his 9 years of believing that the institutional machinery would always, in the end, rotate in his favor had run out. He was escorted down the center aisle of courtroom 302, past the woman who had been holding an eviction folder, past the two men in the third row, past the entirely stunned collection of Monday morning docket fillers who had come in expecting to watch someone else's minor legal problem resolved, and out through the heavy oak doors, which swung shut behind him with a sound like punctuation. The courtroom held its silence for approximately 4 seconds after Jenkins was gone. Then Covington turned to David, and something in her face, for the first time since he had walked through the swinging gate that morning, was not entirely professional. It was not unprofessional either. It was simply human. The expression of a person encountering something that challenges the model they have been using to process the world and finding that the model, in this specific case, was insufficient. "Chief Hutchinson," she said, "when you refused counsel at your arraignment, I couldn't have a public defender, Your Honor," David said. "A public defender would have filed for discovery, which would have required disclosing the bait car records to the prosecution. which would have disclosed the operation to Jenkins before he was in a position where his behavior in court could be captured on the county's own recording system. The perjury on the stand was important, but what we needed most was what he chose to do after the video was shown. He paused. He needed to believe he was winning until the last possible moment. Covington was quiet for a moment. "The system is broken, Your Honor," David said, not with bitterness, with the directness of someone stating a fact that is not pleasant, but is also not a reason to stop working. "The people inside it, the good ones, and there are more of them than the bad ones, sometimes need a specific kind of help, the kind that operates from inside the problem." Covington looked at him for a long time. "I've been on this bench for 19 years, she said finally. "In 19 years, I have never had a defendant tell me no, and then explain to me, in terms I could not dispute, why the answer was correct. I appreciate the opportunity to be heard, Your Honor. You are free to go. Chief Hutchinson." She paused. "And, for whatever it is worth from me, I'm sorry that the system required what it required of you to get here." David nodded once. He picked up his legal pad, completely blank. Every question he had asked committed to memory before he walked through the door, and his cheap briefcase, and walked out through the swinging wooden gate for the last time. What happened in the corridors of the Fulton County justice infrastructure over the following days was not poetic. It was procedural, which is the form that accountability most often takes when it is working as intended, not dramatic, not cinematically satisfying, but thorough, like a piece of machinery that has been repaired and is now simply doing the work it was designed to do. Kinsley's team, operating under the federal warrants that had been prepared over the preceding 8 months, moved through the 4th Precinct's records with the methodical comprehensiveness of people who are in no hurry because they have already locked the exits. They pulled digital communications, financial records, use of force documentation, civil asset forfeiture logs, and the evidence chain records for every case Jenkins had touched in 9 years. They found what they expected to find, and they found several things they had not expected, which is the nature of investigations that are done thoroughly. The civil asset forfeiture records, in particular, told a story. Jenkins and Miller had been conducting pretextual stops in the Oak Ridge neighborhood and 3 adjacent affluent areas for approximately 4 years. The stops produced cash, legally seized under civil forfeiture statutes that allowed the taking of currency when an officer asserted probable cause to believe it was connected to criminal activity. Statutes that required no criminal charge and no conviction. Statutes that had been challenged repeatedly in courts across the country with mixed results because the machinery of their abuse was designed to be difficult to detect from the outside. Jenkins and Miller had seized, over 4 years, approximately $214,000 in cash from stops that Kinsley's forensic accountants could now document as pretextual. Approximately $40,000 of it had been submitted to the evidence lockup per procedure. The rest had moved through an arrangement involving a private account and a series of transactions that a forensic accountant named Chandra Williams, who had a particular gift for tracing money through creative pathways, described in her report as structurally competent, but ultimately not sophisticated enough for the people trying to find it. Kinsley called David with the forensic findings. David was in his apartment, not the safe house, back in his own space, wearing old clothes, eating cereal at 9 in the evening because the decompression after an extended cover operation was its own kind of work, and it didn't always look organized from the outside. "The offshore account," Kinsley said. "We found it 40 minutes after we got Kroll Associates in the room. Williams says it's Jenkins's. The routing goes through 3 shells, but the beneficial ownership comes back to his mother's name. She's 81 years old, lives in Savannah, and I'm prepared to bet everything I own that she has no idea her name is on an account in the Cayman Islands." "How long before you can move?" David asked. "Charges are being filed tomorrow," Kinsley said. "Federal grand jury already reviewed the Weaver case this afternoon, returned an indictment in 35 minutes. David was quiet for a moment. "Marcus Weaver," he said. "What's the timeline on his release?" "His attorney. We found him a good one. A civil rights specialist out of Atlanta filed an emergency habeas petition this afternoon. Given what Miller gave us and what's in the grand jury record, the judge is expected to act within 72 hours. 72 hours, David said. 72 hours, Kinsley confirmed. There was a brief silence on the line. "For what it's worth, David, what you held up in there, in front of that judge, in front of all those people, that's going to matter to a lot of cases we haven't even found yet." The federal trial of Bradley Jenkins was scheduled and conducted 8 months later. Jenkins's defense attorney, a former prosecutor who had made a late career pivot to criminal defense and was known for finding procedural angles in situations where the substantive facts were beyond rescue, reviewed the evidence package compiled by Kinsley's team and called David on a Thursday afternoon. "I need to be honest with you," the attorney said. "I'm not calling to posture. I'm calling because I've spent 3 weeks going through what the government has and I can't find a lane. The bait car footage is clean. The court recording is clean. Miller's testimony is cooperative, detailed, and internally consistent. Weaver's case is... it's going to be the worst of it, in front of a jury." A pause. "He wants to plead." "That's not my decision," David said. "No," the attorney agreed. "But the government's sentencing recommendation is... and Kinsley told me you'd have a view?" David was quiet for a long moment. He thought about courtroom 302, about the woman with the eviction folder, about Henry the bailiff turning his back and staring at the American flag, about Judge Covington saying, "I'm sorry that the system required what it required of you to get here." He thought about James, in Macon, working in a hardware store, the left side of his vision a permanent shadow. "Whatever the guidelines recommend at the top of the range," David said. "I'll leave it to the court." The attorney said nothing. "And tell him," David said, "that the cuffs were his own." Jenkins entered a guilty plea to multiple federal charges on a Tuesday in March. The sentencing was conducted 3 weeks later by the Honorable Patricia Stearns, who had issued the original warrant, in a federal courtroom that was more formal and considerably less eventful than courtroom 302 had been 8 months earlier. Judge Covington submitted her letter as promised. It was 4 paragraphs long, written in the same dry, precise language that characterized 19 years of her judicial writing. And it contained no dramatics and no excess, which made the substance of what it said considerably more effective than drama would have been. Jenkins received 15 years in a maximum security federal facility, without the possibility of parole. Officer Raymond Miller, in exchange for his cooperation, received a significantly reduced sentence and a permanent bar from working in any law enforcement capacity anywhere in the United States, which, as these things go, was the part that would stay with him longest. Thomas Gable, the union representative, was tried separately on his own charges, which were extensive and specific, and was sentenced to 7 years. He was 62 at the time of sentencing. The review of Jenkins's 9-year arrest record, conducted by a joint panel under Judge Covington's oversight, took 14 months to complete. It was painstaking, unglamorous work. The review of case files, evidence logs, witness statements, and plea deals that had been accepted by people who had no way of knowing that the evidence against them was manufactured or the officer testifying was lying. It required the cooperation of multiple public defenders' offices, the district attorney's office under new leadership after the incumbent declined to seek re-election, and a team of volunteer attorneys coordinated by a civil rights organization based in Atlanta. The panel ultimately identified 47 convictions that required further review. Of those, 39 were vacated. 26 individuals who had served time or were currently serving time for things that had never happened, or that had been escalated by an officer manufacturing conditions for a charge that wouldn't otherwise exist, were formally exonerated by the court. Marcus Weaver was among the first. He walked out of the facility on a Thursday morning, into a parking lot where Kinsley's office had arranged for an advocate from the civil rights organization to be waiting. Weaver was 23 years old. He had spent 9 months inside. He shook the advocate's hand, walked to the car, got in, and asked to go to a diner because he had been thinking about a specific kind of breakfast for a specific number of mornings. He did not find out until 3 days later, when his attorney called him, that the man who had designed the operation that put Jenkins in prison had been paying his law school application fees from a private account for the past 8 months. The attorney had been instructed to keep the source anonymous until after the sentencing was complete. Weaver sat with that information for a while. Then he asked the attorney for a contact address, wrote a single handwritten letter, and mailed it. David received it 11 days later, on a naval base in Virginia. He read it twice. He folded it and put it in the breast pocket of his uniform jacket. He did not write back. He didn't need to. Everything that needed to be said in that direction had already been said in the form of action, which is the only language he had ever found completely adequate for the things that mattered most. The Department of Justice consent decree that was placed over the Fulton County Metro Police Department, specifically over the operations of the 4th Precinct and its adjacent units, was announced at a press conference that David did not attend and did not watch. He was, at the time it was being announced, in a gym on a naval base at 5:30 in the morning, doing exactly the kind of workout that is not about performance and not about fitness in any formal sense, but about the specific management of a mind that doesn't stop working when the body is inactive. 3 miles on the treadmill, 40 minutes of compound lifting, 20 minutes of bag work, which he found most useful, not because of the striking itself, but because of the rhythm, the 3-count rhythm of jab, cross, hook that, if you've done it enough times, produces a particular quality of mental quiet that is difficult to replicate through other means. He had been back in his actual assignment for 6 weeks. He had debriefed with Kinsley's team, completed the required psychological evaluation that the Navy mandated after any extended cover operation, and written his operational report, a 73-page document that was classified at a level above what most people in the courthouse on the day of the trial would have clearance to read. He had taken 4 days of leave, which he had spent at his mother's house in Atlanta, not discussing the case, not watching the news, eating his mother's cooking and sleeping 9 hours a night and allowing his nervous system to recalibrate. He had also, on the 2nd day of leave, driven to Macon. James's apartment was on the 3rd floor of a building on a quiet residential street, the kind of building that is not particularly anything, not bad, not good, just the place where someone is living while they're figuring out what comes next. David had called ahead. James had buzzed him up without saying much. The apartment was small and clean. James was 24, and he looked older than that in the way that certain experiences age a person. Not the face exactly, but something behind the face, a particular quality of attention that people develop when they've learned that the world doesn't necessarily hold together the way they were told it would. He had known, in general terms, what David was doing. He'd known for months. David had told him before the operation began, had needed to, both because James deserved to know and because there was a practical possibility that Jenkins's attorneys would attempt to draw connections, and David needed James to be prepared. What James had not known, until the week before David came to visit, was the full extent of what the investigation had uncovered, or the number of people whose situations would be different because of it. They sat at a small kitchen table with coffee and James's particular brand of silence, which was not hostile and was not warm, but was simply the silence of a person waiting to understand what they were supposed to feel about a thing. 39 convictions vacated, James said. Eventually, it wasn't a question. So far, David said. The review isn't finished. James turned his coffee cup in small rotations on the table surface. The 2 years, he said, the 2 years I wasn't in school. He wasn't saying it as an accusation. He was saying it as a fact he was examining. Yeah, David said. Nothing fixes that part. No, David said. Nothing fixes that part. They sat with that for a while. James turned his coffee cup. Outside, a car passed. The refrigerator made a small sound. The 26 people, James said. The ones who were inside. 26 exonerated. So far, David said. More possibly coming as the review completes. James nodded slowly. The nodding of someone integrating information not for its own sake, but for what it implies about the structure of the world. He was quiet for a long time after that. Then he looked at David with the left eye that could still see properly, and the right eye that could see a shadow, and said, "Is it worth it? What you do?" David thought about courtroom 302. He thought about the video playing on the monitor, his own hands, raised and empty, in the frozen frame. He thought about Judge Covington's letter. He thought about Marcus Weaver's handwritten note, folded in his breast pocket. "Yes," he said. Not quickly, not as a reflex. After the pause that the question required, James turned his coffee cup one more time. Then he got up and refilled both of theirs. The consent decree required mandatory body camera usage and third-party monitoring of all footage. It required the retraining of every officer in the affected units on a set of protocols specifically designed by an independent panel, not a panel appointed by the department, not a panel selected from existing law enforcement structures, but a panel that included civil rights attorneys, community representatives, and use of force experts from outside the state. It required the establishment of an independent civilian review board with actual subpoena power, which was the distinction that made it functionally different from the purely advisory review boards that had existed before, which is to say, the distinction that made it mean something. It required, in one specific and deliberately worded clause, that any officer against whom 3 or more substantiated excessive force complaints had been recorded within a 5-year period be subject to mandatory review by the civilian board. This clause was drafted in response to the specific documented history of Jenkins's complaint record, and it was worded in a way that made it applicable going forward regardless of rank, tenure, or union status. The union. Under its new leadership, Gable's replacement was a woman named Patricia Donner, who had spent 12 years as a patrol officer and had no interest in repeating her predecessor's professional trajectory, submitted formal comments on the consent decree's requirements, and, after the comments were reviewed and 3 modifications were made to the implementation timeline, formally accepted the terms without litigation. This was unusual. It was not unprecedented, but it was unusual. Kinsley called David to tell him about it, not because David needed to know operationally, but because it seemed like the kind of thing David would want to know. "The new union rep?" Kinsley said. "Donner. She said something at the sign-off meeting." He paused. "She said, the people who wore the badge right are not protected by protecting the people who wore it wrong. They're protected by the opposite." David was quiet for a moment. "She's going to be fine," he said. "Yeah," Kinsley agreed. "I thought so, too." There is a thing that happens to people who have spent long periods of time operating under the requirement of sustained control, the kind of control that requires you to experience things fully while displaying nothing. And the thing is that the processing of those experiences tends to be deferred rather than avoided. You put it somewhere until the operational context allows for it to be addressed. And then, when the context changes, when the mission is complete, and the debrief is done, and the report is filed, and the gym session is finished, and the coffee is poured, the processing happens. It does not happen dramatically. In David's experience, it does not announce itself. It simply begins to occur, quietly and without particular ceremony. In the spaces between things, in the car on the way to somewhere, in the 30 seconds before sleep, in the middle of a conversation about something completely unrelated that suddenly produces a question from the back of a room in your mind that wasn't there before. The question that kept coming back was not about Jenkins. It was not about the case, or the evidence, or the courtroom, or any of the operational elements of what had taken place over the past year and a half. It was about the people he had not been able to help, the ones whose names were not in any file that had been reviewed, because their cases hadn't produced enough documentation to surface in the audit, or because their situations had never formally entered the justice system at all, or because they had simply made the calculation a rational, experience-based calculation that nothing they did would change anything, and had not tried. The ones who existed in the negative space around every documented case. The ones who would never know that 39 convictions had been vacated. The ones for whom the consent decree would make the future marginally better, but could not touch the past. He thought about this without resolution, which is the appropriate way to think about things that do not have resolution. You hold them, you don't put them down, and you don't pretend they aren't there. You carry them, and you keep doing the work, and you accept that the two things can coexist, the grief for what couldn't be fixed, and the determination to fix what could be, without either one canceling the other out. This was not wisdom he had come to easily. It was something he had learned from people who had taught him harder things under harder circumstances. But it was wisdom, and it was his. And on the mornings when it felt like enough, he was grateful for it. And on the mornings when it didn't. He went back to the gym and the 3-count rhythm and the particular quality of quiet that followed. Weaver's letter had been 3 paragraphs long. David had expected, when the attorney told him it was coming, something that would be difficult to read, not because it would be negative, but because expressions of gratitude in situations like these tend to carry a weight that the words themselves are not designed to support, and reading them requires a particular bracing. It was not like that. Weaver wrote the way someone writes when they've had 9 months of early mornings and late nights to think about what they actually want to say, which is to say, directly. He wrote that he was going back to school in the fall. He had been admitted to his original program, and the dean had personally written to tell him that his 9 months of absence would be treated as a medical leave and would not affect his standing. He wrote that he was angry, and that he expected the anger to be with him for a long time, and that he was deciding what to do with it rather than letting it decide for him. He wrote that he did not know David's name because the attorney had honored the request for anonymity, but that he was writing to whoever it was because the specificity of the law school fees suggested a level of attention to his particular situation that deserved a specific response, even if the response went nowhere. And then he wrote, "I don't know why you did what you did, or what it cost you, but I know it wasn't nothing. So, thank you. Not for what happened to him, for what happened to the other 25. David read this line 4 times. The 26th name had not been forgotten. It was simply being handled differently, with the particular, careful attention of someone who understands that some things are not adequately addressed by being included in a list. However important the list is, Weaver was right that it wasn't nothing. He was also right to thank David for the others first. 6 months after the sentencing, David was assigned to a new task force. The assignment came through Kinsley's office, with a formal request from the DOJ that was also an informal acknowledgement that the methodology of the Hutchinson operation, the concept of using a subject with the training to withstand what an ordinary civilian could not, to create an evidentiary record that the normal investigative process couldn't produce, had produced results that argued for its considered replication in the right circumstances. The briefing document for the new assignment was 40 pages long. David read it on a Sunday afternoon, took notes on a legal pad, and identified 4 elements that needed clarification before he could assess feasibility. He called Kinsley with the questions. Kinsley answered 3 of them and said he'd have an answer on the 4th within 48 hours. "One other thing," Kinsley said, before they hung up. "Yeah," David said. "The Weaver kid. He started law school." David set down his pen. "He's specializing in civil rights," Kinsley said. "Civil rights and wrongful conviction. The program director said he came in the first week with a brief already written on forfeiture abuse. She said it was, and I'm quoting her directly, substantially better than work we see from second-year students." David said nothing for a moment. "Good," he said. "That's good." After he hung up, he sat at his desk for a while. Outside the window, the late afternoon light had that particular quality it gets in Virginia in October, low and gold and slightly hazy, the kind of light that makes familiar things look briefly different, worth pausing over. He looked at it for 30 seconds, which was longer than he usually allowed himself for things like that. Then he turned back to the 40-page briefing document, picked up his pen, and got back to work. 2 years and 4 months after the day Jenkins was handcuffed with his own cuffs in courtroom 302, a woman named Dr. Lorraine James, professor of constitutional law at Emory University, and the author of the most widely read academic analysis of the Hutchinson case to appear in any legal journal, was asked in a radio interview what she thought the case's lasting significance would be. She thought about it for what the radio host described, in real time, as an unusually long pause for live radio. "The case is interesting for a lot of reasons," she said finally. "But the thing I keep coming back to is this. It didn't work because of the law. The law was already there. Title 18, Section 242. That statute predates the civil rights movement. The legal mechanisms for what happened in that courtroom were not new. What was new was a particular individual's willingness to put his body into a situation where the law could actually function, and his ability to control his response to what happened to him in that situation well enough that the evidence remained usable. The law needed a human being to carry it into the room." The host asked whether that was a sustainable model. "Of course not, Doctor," James said. "It can't scale. You can't train an army of people to do what he did. That's the point. What you can do, what the consent decree attempts to do, what the Civilian Review Board attempts to do, is change the conditions so that individual acts of extraordinary discipline are not the only mechanism available. The goal is a world where Marcus Weaver never needs someone like David Hutchinson to stand between him and what happened to him. We're not there. But we moved." She paused again, shorter this time. "We moved?" she said. "The Civilian Review Board held its first formal hearing 14 months after the consent decree was signed. The case before the board involved a different officer, a different precinct, a different neighborhood, a different complaint. The officer's name was not Jenkins. The circumstances were not identical, but the pattern was recognizable. Pretextual stop, escalation without apparent provocation, Physical force applied in a manner that the department's own use of force guidelines did not support. A complaint filed. The complaint processed through the previous internal review mechanism, the one the consent decree had replaced, and dismissed. The board reviewed the body camera footage, the complaint, the officer's prior complaint history, and the use of force report. They called the officer before them. They called the complainant. They heard both sides in full. The board found the complaint substantiated. They recommended the officer's suspension, pending additional investigation by an independent examiner. The officer's union representative, Patricia Donner, was present for the hearing. Afterward, she was asked by a journalist covering the board's inaugural session whether she intended to contest the board's finding on the officer's behalf. She looked at the journalist with the expression of someone who has thought very carefully about where the lines are, and has drawn them deliberately, and does not plan to move them. "No," she said. "We don't contest substantiated complaints. That's the policy. If you want to write something about that, write something about that." The journalist wrote something about it. Several other journalists wrote about it. Donner did not find this interesting enough to comment on further. Jenkins's mother, Vera Jenkins, was 81 years old and lived in a small house in the Ardsley Park neighborhood of Savannah, Georgia, 3 blocks from the house where she had grown up and 5 blocks from the elementary school where Bradley had gone, and where she had volunteered in the reading program every Thursday for 11 years. She had not known about the account in her name. The federal investigators' determination on this point was unambiguous. The documentation, the communication records, the pattern of transactions, all of it made clear that she had been used without her knowledge or consent. The account was forfeited. She was not charged. She did not attend any portion of the legal proceedings. She did not speak to journalists. She continued to live in her house in Ardsley Park, and she continued to attend the same church she had attended for 40 years. And she was seen by neighbors in the period following the sentencing to be doing what people do when something enormous and terrible has confirmed itself fully, moving through ordinary days carefully, with the specific quality of attention that belonging to ordinary life requires from someone who has been shaken by extraordinary things. David thought about her. Occasionally, not with guilt. The operation had been necessary, and the determination of Vera Jenkins's non-involvement had been thorough and was not in question. He thought about her the way he thought about the uncounted people, with the recognition that the consequences of a person's choices radiate outward further than the person who made them will ever be asked to account for, and that this was one of the truest and most difficult things he knew about how damage worked. He sent no letter. There was nothing he could have said that would have been adequate, and he had long since learned to distinguish between the situations in which an imperfect gesture was better than silence and the situations in which it was not. This was the latter. He left it alone. The day Marcus Weaver started law school, he wore a dark blue blazer that he had bought the previous week at a department store. He had looked at it on the hanger and thought, briefly, of nothing in particular, and then bought it because it fit, and because he needed something for the first day, and because this was what you did. He arrived early. He sat in the 3rd row of a large lecture hall. The professor opened her remarks by asking the class to consider a question. What is the law for? Not what is the law, she clarified that distinction, but what is it for? What does it exist to accomplish? What happens in the space between a law written on paper and the experience of a person encountering a situation that the law was theoretically designed to address? What is the relationship between those two things, and whose job is it to tend it? The class offered various answers. Some were formal, some were philosophical, some were practical. Weaver did not speak during this discussion. He sat in the 3rd row with his notebook open and wrote 2 words at the top of the first page. Fix it. That was his answer to the professor's question. He didn't say it aloud. He didn't need to. It was the answer he carried, not for the class or for the grade or for anyone who would read it, but for himself, for the 9 months, for the letter he had written to an unknown address, for the 26, now, with the review panel's final report completed, 39 babes that had been on a list, each one a whole person, each one a whole life, each one representing a specific instance of the machinery being used against the people it was supposed to serve. He wrote "Fix it" at the top of his notebook. Then he turned to a fresh page and started listening. The last record of David Hutchinson in the operational files of the Joint Task Force, before the case was formally closed and the materials were archived under the appropriate classification level, was a single line in the activity log for the day of Jenkins's federal plea. The log entry read, "Chief Hutchinson notified of guilty plea. Response, acknowledged. Return to duty." That was the entire entry. There was no elaboration, no statement, no recorded reaction. For the log's purposes, it was a complete account of what had happened. In the margin of the printed copy that Kinsley kept in his personal case file, not the official record, his own copy, the copy that would not be archived, he had written 3 words in pen. Good work. Chief, this was the entirety of the tribute that the operational record contained. It was, David would have said if asked, about right. On a Tuesday afternoon in November, 2 years and 7 months after courtroom 302, David sat at a desk on a naval base in Virginia and read a 40-page briefing document about a situation in another city, in another jurisdiction, involving a different department and a different officer and a different set of people whose names he did not yet know but would. The window behind his desk showed the gray November light over the Chesapeake, the water flat and slightly silver, the kind of sky that means winter coming. He had a cup of coffee at his right elbow, going cold, which was how his coffee usually ended up. He read the document all the way through. Then he turned to the notes he had taken. Questions, clarifications needed, operational gaps that would require additional information before an assessment was possible. And he added one more item to the list. Who else did this? Not the officer. He knew who the officer was. He meant the people underneath, the ones the complaints had been filed against, the ones whose cases sat in the negative space around the documented record, the ones who had never filed anything because the calculation had told them filing was pointless. Those people. Who were they? What had happened to them specifically, in detail, with names and dates and what the record showed and what it didn't? He would need that before he could do anything useful. He picked up his phone and called Kinsley. "I've read the briefing," he said when Kinsley picked up. "I have questions." "How many?" Kinsley asked. "Start with 5, David said. "I'll have more after. When do you want to meet?" David looked at the window, the gray light over the water, the coffee going cold at his elbow. "Tomorrow morning," he said. "Early." He hung up. He picked up the cold coffee and drank it without complaint, because there was work to do, and the work was what mattered, and he had learned a long time ago, in rooms considerably more difficult than this one, in circumstances that made a Fulton County courtroom feel like a controlled environment, that the discipline required to do the work was not a condition you achieved and then maintained. It was something you returned to every morning, every brief, every phone call at 5 in the morning, every cold cup of coffee. You returned to it, and the returning was the point. Outside, the November light shifted slightly, the water catching it for a moment before the clouds closed again, and the day continued, ordinary and necessary and moving forward in the way that days do when the people responsible for tending to what matters are still, quietly, at their posts. Marcus Weaver graduated from law school on a Thursday in May. 3 years after the morning he had walked out of a correctional facility into a parking lot and asked someone he'd never met to take him to a diner for breakfast. He wore a robe and hood that were slightly too warm for the weather. He sat in the third row of the graduating class, which was where he had sat in every lecture for 3 years, because he had decided at the start that sitting in the back was a statement he didn't want to make. When his name was called, he walked across the stage with the particular quality of movement that belongs to someone who has had 9 months to think very precisely about what walking across a stage in a cap and gown would mean, and has arrived at an understanding that is too specific and too personal to put into words easily, and has decided that the walking itself is the statement. He shook the dean's hand. He received his diploma. He walked back to his seat. In the audience, his mother was crying in the way that people cry when the thing they are witnessing is not only the thing it appears to be, but is also everything that almost prevented it. His sister, 2 seats to the left, had given up on composure approximately 40 seconds before his name was called. His father sat with his hands folded, not crying, simply looking at his son with the expression of a man who has been carrying something very heavy for a very long time and has just, in this specific moment, been allowed to set it down. 3 weeks after graduation, Weaver received a letter. The return address was a naval base in Virginia. Inside was a single index card. On it, in handwriting that was spare and deliberate, were 4 words. "You did the work." No signature, no address for reply, just the 4 words and the postmark. Weaver put the card on his desk, next to the notebook from his first day of law school, the one with "Fix It" written at the top of the first page. He looked at them for a while, the 4 words and the 2 words, "everything that mattered," in 6 words total. Then he opened his laptop, pulled up the case file he was currently working, a wrongful conviction appeal for a man in Chatham County who had been inside for 11 years, and got back to work. Justice doesn't always announce itself. Sometimes it walks in wearing a cheap suit, with nothing but a legal pad and the patience to let the truth do what the truth does, in its own time. When the conditions are finally right, sometimes that's enough. Sometimes, carefully and stubbornly, and by the specific work of specific people who refuse to stop, it's more than enough.